The evidence essay from July of 1999 is a classic example of the transcript format evidence essay question pioneered by the California bar examiners. Have a look at the call of the question. What objection or objections could Dr. Jones' attorney reasonably have made to the question or answer at each of the places indicated above by the numbers in the left-hand margin, and how should the court have ruled in each instance? Discuss. Well, here, I'm not even going to review the fact pattern. We can just look at my outline of issues, and it will do just as good a job. But a couple of ideas up front. This type of question, more than any other, shows just how foolish it is to plan on writing a lot of boilerplate at the beginning. If you put down a page or a page and a half of boilerplate, like that recommended by Barbary, to an answer to this question, you'll never finish under time constraints. And even doing it my way, writing as fast as you can, it's still a challenge to finish this question. So I've said that evidence questions are the easiest essay questions from all the multi-state subjects. And I mean it. Systematically, this is not very hard stuff intellectually. But it is a challenge to finish under time. And so organization becomes the key. Another point that I will tell you up front is this. The call of the question is asking for objections, and that means we want to come up with as many objections as we can to each one of the indicated bits of evidence. And so having a nice checklist in your mind of the objections is useful, and the best way to develop that checklist is by doing a lot of practice essay questions. You'll start to begin to see a pattern develop, because here, just as is the case throughout evidence, and really throughout all of the California bar exam, the issues are tested over and over again in a ritualistic fashion. One other idea that I present up front before we get into reviewing the issues presented by this fact pattern is not only do we want to leave out the boilerplate here even more than elsewhere on the bar exam, but I do one thing in my answers to these transcript questions that might strike some of you as being a little bit counterintuitive. Generally speaking, I lead off with a little discussion of relevance for each item. I don't usually give it a separate section, and as you'll see, sometimes I leave it out altogether. But whenever I can, I work in a line item about why the evidence would be of any interest to the party that is offering it. So, with all of that said, have a look at my outline of issues. Here you'll see that I use the evidence itself as the headings. I quote from the evidence at the Roman numeral level of the outline. That's why I think it's just as easy to review the fact pattern, this fact pattern, by looking at this outline than I would think by actually looking at the question itself. They're pretty similar. Another point that's worth making here and elsewhere is if you are one of those increasing number of candidates who take the exam on a laptop, here, your outlining work can streamline your answer, because here, as in all of the other outlines I present, I use the outline as the structure of my analysis. By the way, I handwrite my answers during practice, and then I type them up later. Even on the bar exam itself, back in 1984, at the time, I could touch type 50 words a minute with my eyes shut, and I still chose to handwrite the exam. Well, one factor of my status as a creature of habit is I still do my work by hand first. But if I'd grown up during the computer era, I'm sure I would have taken the exam on a laptop. So now let's turn to the outline of issues. You'll see at item 1, I quote from the testimony. We've got counsel cross-examining the defendant. And so it's okay for the questioner to lead this adverse witness, even if the lawyer calls that witness for his own case in chief. If the witness turns on the questioner, it's okay to lead them. In part 2, question 2, we're dealing with the witness's answer, and the doctor answers, no, it's not part of our procedure. The no part is responsive to the question presented. The rest of it is non-responsive, and so a motion to strike would be appropriate, and the judge should grant it. Moving on, in the third item that the examiners direct our attention to, we deal with a question asking, really, about subsequent remedial measures. Well, since the operation on the plaintiff, you test the drills, right? Well, that's logically relevant, but legally it's subject to an objection over policy, the subsequent remedial measure policy. The bottom line is, this is an objection that every judge in the country would be wise to sustain, lest a fear of reversal on appeal. Next, in item 4, we have a hearsay objection to a question being asked the doctor about something a nurse said during the operation. She observed that the drill looked a little wobbly, and that's the objection. Hearsay. There's an exception, the present sense impression, and a possible non-hearsay way to examine the situation, supposing that the out-of-court statement is offered for its effect on the listener. Either way, I overrule the objection and move on to item 5. Here, the questioner is asking the doctor about the nurse's report in which she writes that the drill bit looked wobbly. Here, for a change, the examiners give us one of the objections. The doctor's reply is that it was the nurse's opinion. So we can object about whether or not it was proper for the nurse to hold or express that opinion. And as we'll see, I think it was entirely appropriate. The next objection is hearsay, given that the report was from out of court. The business records exception applies. I overrule the objection. Next, in item 6, we turn to a question that the lawyer asks the doctor about material in a textbook. This is hearsay, and one of the rare instances on the California bar exam where the learned treatise exception to hearsay is being tested. Ultimately, I'm going to overrule the objection. In item 7, the doctor is being questioned about allegations of sexual misconduct. This is flatly irrelevant to the case at bar, but also it is improper character evidence and it's hearsay. Here we can see in item 7, I'm coming up with as many objections as I can. As we'll see, I try to find a home for the facts. I even talk about relevance when we're not being directly questioned on relevance. But when it comes time to deliver the goods, which in this question are the objections, I come up with as many as I reasonably can. Similarly, in item 8, here we are looking at a character objection to the last question, and once again, I'm going to sustain the objection. So we've got a racehorse question on our hands here, and we're going to race through it. But just because we're in a hurry, we don't have a license to do overly hasty or sloppy work. So let's take a look at my answer for a few minutes, because I want to show you how to try to make your answer as reader-friendly as possible. And you'll notice here, once again, there is no boilerplate. We just don't have time for it. We're in a big hurry to do our analysis. So look at how I present my analysis to the first item that the examiners have directed our attention to. I quote from it, and I use that quote as the heading. Notice how I indicate why the question is relevant. Why do I do that? Because relevance is a part of a complete analysis for evidence, and because I think it helps tell the story to include a very brief discussion of why the party might have presented the evidence at question. But you'll see I focus the bulk of my analysis on the objections. The objection here is that it's a leading question. Still, it is an appropriate question, and the objection should be overruled. Next, we move on to the second item, and here again, I quote from the testimony and use that quote as the heading. The objection is that the answer is non-responsive in part, and the part after the word no, I will strike as non-responsive. Then we turn to item 3, and here we're not doing anything more complicated than we were able to spot at the outlining stage. Look at the first couple of sentences I present up front. Here I am leading with the facts, which are in the heading, and I indicate the plaintiff's second question is designed to buttress the plaintiff's case in chief. And the obvious objection is subsequent remedial measures, a policy objection based on relevance. I sustain that objection and move on to item 4. Here we are questioning the doctor about the nurse's observation during the surgery. Notice, you'll see how I tell the story about with its relevance, and then I set up the hearsay analysis. Here I do a fairly elaborate job, particularly under time constraints. The statement was made out of court. It's offered to prove the truth of the matter asserted in court, at least arguably, and thus the hearsay definition is worked into the definition. The exception is present sense impression, and the non-hearsay aspect could be effect on the listener. You can look at these two short paragraphs and see that I do a reasonable job of tying the facts to the law. My conclusion, I overrule the objection as an exception to hearsay or as non-hearsay. We move on to question 5, where the lawyer is questioning the doctor about the statement in the nurse's report. Here the evidence is relevant, again, because it supports the plaintiff's theory of liability. Also, the earlier question, I note, satisfies the requirements for a foundation, authentication, and best evidence. So we move into the real objections here, the improper opinion of the nurse and the double hearsay problem. And you'll see, I do it, again, as concisely as I can without sacrificing the fundamental quality of the analysis. In the end, I'm going to overrule these objections and allow the testimony to come in. Next, in item 6, we deal with the learned treatise exception to hearsay. We touched on this as we were reviewing the outline, but look at how I set up the analysis. I offer 2 sentences up front about what the status of the litigation is and what counsel is trying to do with the doctor. It looks like we've got a properly authenticated document, so I move on to the hearsay and learned treatise exception. In the end, I overrule the objection and I allow it to come in. Next, we turn to an item which I just flatly think is irrelevant. The question where the lawyer is questioning the doctor about allegations of sexual abuse by other patients. That doesn't have anything to do with the doctor's competence in treating this plaintiff. And so I just don't think it's logically relevant. I make that objection up front. Next, we turn to the character evidence and the evidence of prior bad acts. Sexual abuse isn't relevant to whether or not this guy is competent vis-a-vis the current plaintiff. So I'm not very impressed with this as valid character evidence either. I think it's invalid. We move on to hearsay. The bottom line is I sustain all of the objections. I just don't like this testimony and I'm not going to let it come in. Finally, we turn to the last line item from the fact pattern where there is a question being asked about 2 other operations the doctor performed where the drill bits slipped, causing injury. This is relevant because it suggests this doctor has made this mistake before. The problem here is that we've got another character evidence objection based on specific bad acts. And since the proffer is not being made to show dishonesty or habit and practice under the mimic principle, I just don't think that this evidence ought to come in. It's a lot more relevant than the previous question involving sexual misconduct, but in the end, I just don't think the doctor's character is at issue. I think that this objection ought to be sustained. And given all of the other very prejudicial evidence that's coming in, I would expect that the doctor in the end is going to face liability.